meetings in regard to important income tax topics. And today's topic is the important issues and controversies in relation to notices under Section 148A and orders passed pursuant thereto and effect of changes by Finance Act 2024. And our speaker today is Mrs. Prem Lata Bansal. Everybody knows her. There is no the need for any introduction. She is a senior advocate in Delhi, and she has been the past president of the AIFTP. And as far as the subject is concerned, all this controversy, section 148A and other sections had come into force in 2021. And since then, a lot of controversies have arisen. And now further the amendments, even the controversies had not settled. Now there is a further amendments made in 2024, which may further give rise to all the litigations. So without wasting any time, I'll firstly request our president, Mr. Narayan Jain, to make his opening comments, and then we'll request Mrs. Prem Lata Bansal to take up the topic.
Thank you, Gupta ji, and welcome Prem Lata Bain.
Thank you, sir.
फ्रेंड्स, ये इनकम टैक्स तो ऐसा चीज है, अमेंडमेंट हो चाहे पुराने हो, बार बार पढ़ो, जितने बार पढ़ेंगे उतना ज्यादा आपका कंफ्यूजन जो है बढ़ भी सकता है, घट भी सकता है। और ये इनकम टैक्स जितना कॉम्प्लिकेशन या इसकी ड्राफ्टिंग ऐसी होती है तो अपने प्रोफेशनल के लिए अच्छा है। हर बार गवर्नमेंट ऑफ इंडिया जो है अपने लिए नई नई चीज लाती है। पहले वाला भूलो, नया याद करो, पुराने वाले मैटर भी चलते रहेंगे, पुराने सालों के भी। तो ये क्या है कि वी हैव टू लिव विद व्हाट वी आर सर्व्ड। ये तो आपको खाना जो दिया जा रहा है उसी को खाना है और खिलाना है। तो ये बेसिकली ये प्रोविजंस में मैं नहीं जाना चाहता, क्योंकि ये जो है ये तो प्रेमलता बहन का जिम्मेदारी है। लेकिन ये जो गवर्नमेंट बार बार जो चेंज करती है, रीओपनिंग के प्रोविजंस और फिर सैंक्शनिंग अथॉरिटी 151 में इन्होंने स्टार्ट किया था प्रिंसिपल चीफ कमिश्नर से, जो भी लाते लाते भी आगे ये लोग ज्वाइंट कमिश्नर, एडिशनल कमिश्नर पे। तो पहले भी जो प्रिंसिपल चीफ कमिश्नर ऑफ इनकम टैक्स या डायरेक्टर जनरल थे, तो एक एक दिन में 100 फाइल आदमी के लिए, उसको एप्लीकेशन ऑफ माइंड जो हम लोग कानून में बोलते हैं, इसको समय नहीं है देखने का। वो तो जो नीचे से आता उसी को साइन कर दो। या कई यहाँ हमारे कलकत्ता में कुछ ऐसे प्रिंसिपल सीसीआईडी थे जो रीओपन नहीं करने का भी सजेशन है, उसको बोले रीओपन करो। तो ये जॉइंट कमिश्नर जो है या एडिशनल कमिश्नर जिनका दायित्व अभी दिया है 1 सितंबर 2024 से, हम लोग यही उम्मीद करें एज ए प्रोफेशनल कि वो लोग कोई अपना दिमाग अप्लाई करें, फैक्ट्स को देखें और ये लोग भी डिसाइड करें। उससे पहले अच्छा ये रहे कि पार्टी को या उसके एडवोकेट को एक मौका दे, क्योंकि कई बार क्या होता है कि जैसे मैंने देखा है पास्ट में, मेरे को उसके लिए हाईकोर्ट में मूव करना पड़ा कि हमने जवाब दे दिया, मेरे पास रिसीट है सब कागजों का, इसके बावजूद भी ऑफिसर लिखता अपना रिपोर्ट में कि नो रेस्पॉन्स वाज मेड। फिर मैंने हाईकोर्ट में देखा कि देखिए साहब ये छाप लगा हुआ है, तब हाईकोर्ट ने उसको थोड़ा सा दकाल वकाल मार के कहा कि नहीं इनका करो। और क्योंकि हाईकोर्ट घूम के गए थे वहां पर मैटर में, तो फिर वो ऑफिसर ने हमारी बात मान ली और मैटर को ड्रॉप कर दिया। तो लेकिन क्या है कि ये परेशानी है, हाईकोर्ट पार्टी जाएगा, खर्चा है, चिंता फिक्र है। तो ये हम लोग को, आप लोग की अनुमति होगी प्रेमलता बहन की, तो हम लोग एक ये लिख सकते हैं गवर्नमेंट को कि ये सैंक्शनिंग अथॉरिटी कोई भी चीज पे विचार करे, सैंक्शन करें, उससे पहले पार्टी को या उसके एडवोकेट को भी हेयरिंग का एक मौका दें। तो उससे क्या होता है कि कई बार चीजें जो है वो छुपी हुई रहती है, फाइल में नहीं रहती है, ऑफिसर नहीं लिखता है, हाईलाइट नहीं करता, तो वो भी सामने आ जाएगी। तो ये इसी बात के साथ जो है मैं तो सुनने आया हूँ प्रेमलता बहन को, और हमारे जितने भाई आज आए हैं, वी आर ऑलरेडी 81 मेंबर्स, आई थिंक सून वी विल एक्सीड 100 मेंबर्स। तो ये हर एक पॉइंट को हम लोग ध्यान से सुनेंगे, प्रेमलता बहन जो बोलेगी, और उस पर हम लोग काम करेंगे, अपने प्रोफेशन में प्रैक्टिस में काम में आएगा, ये मुझे उम्मीद है। कई लोग को देखता हूँ बहुत इंपॉर्टेंट पर्सन भी है, तो मैं किसी का नाम नहीं ले रहा हूँ, लेकिन गणेश परोज जी का जरूर मैं नाम लूंगा कि वो भी एक गुरुजी है। तो बीच बीच में जब भी जरूरत हो तो आप भी जरा बोलिएगा। काकरा जी भी आ गए, बहुत बहुत धन्यवाद, आपका सबका स्वागत। गुप्ता जी, आपका आवाज नहीं आ रहा है।
Good evening, sir.
गुड इवनिंग।
Jain sir, you are not audible. You are not audible properly. Jain sir,
हाँ, अभी आवाज आ रही है?
आप आवाज बीच बीच में
हाँ
रुक जाती है आपकी।
हाँ,
मैडम, हो गया जैन साहब का, अब आप जो है स्टार्ट कर सकते हैं।
Have you concluded?
हाँ
हाँ,
हाँ,
ये
जैन साहब ने
conclude
कंक्लूड
कर
कर
दिया।
दिया।
सर बीच में रुक रही है।
चलो कोई बात,
मैं
सब्जेक्ट आपके
मैं
लिए छोड़
स्टार्ट
दिया जैन
करूं
साहब।
क्या?
जैन साहब
जैन
ने
साहब
सब्जेक्ट
की
आप
आवाज
जैन साहब ने सब्जेक्ट आपके लिए छोड़ दिया है,
कंक्लूड
आप
कर
स्टार्ट
दिया
करें।
क्या? जैन
हाँ
साहब
जी
ने
जी
नहीं
मैम,
हाँ जी
कर
हाँ
दिया
जी
कर दिया
हाँ
कर
जी हाँ जी
दिया
हाँ जी
ज्वाइन
हाँ
कर
जी।
लिया उधर।
मैम मेरे
अच्छा,
को।
मैं स्टार्ट करूं?
हाँ जी
प्लीज
मैम, मेरे
प्लीज,
को
हाँ
लगता है
प्लीज।
आपको कोई नेटवर्क इशू है, आपको आवाज नहीं प्रॉपर आ रही मेरा ख्याल।
ऑनरेबल,
यस मैम।
हाँ
हाँ, जैन साहब की आवाज बीच बीच में कट रही है, तो इसलिए पता नहीं चल रही कि मैं स्टार्ट करूं।
हाँ
गुप्ता
हाँ,
जी,
आपकी आवाज आ रही है, आप
में,
स्टार्ट
और
करें।
आपका जब पूरा हो जाएगा
मेरी
तब मैं
आवाज
थोड़ी सी बात
क्लियर है
बोलूंगा।
ना?
हाँ आपकी आवाज आ रही है, आ रही है
ठीक है, ठीक है।
जी।
Right, sir. Honorable President, Mr. Narayan Jain, Ganesh Purohit, sir, Gupta ji, doyen of the tax subject as well as direct tax committee, and other dignitaries. I am taking this opportunity, and for this I am highly obliged for giving me this opportunity. And without wasting any time, I am starting with the subject. Please, sir. Sir, everybody knows regarding reassessment. वो आज के दिन तो यही हमारा अन्नपूर्णा देवी समझो कि रीअसेसमेंट लिटिगेशन इज अन्नपूर्णा फॉर ऑल ऑफ अस. So department is using trial and error method for reassessment proceeding, reassessment scheme. Since 1980, reassessment provisions are on the statute book, and time and again in 1918, 1922, then 1948, 49, 61, then 89, and in by Finance Act 2021 has overhauled the entire reassessment scheme to assess the escaped income of the SSC. The purpose is to assess the income of the SSC in the proper hands and in the very assessment year to which it belongs. The income of the year is to be assessed in that very assessment year. It cannot be assessed in any other year. So as per the provisions existing till 31/3/2021, assessing officer had got jurisdiction to issue the notice to reopen the assessment on recording of regions, having cogent material, having live link with the information and belief that income of the SSC has assessed assessment. This material, and thereafter GK and drive shaft was decided by the Honorable Supreme Court, stating that first the opportunity is to be given to the SSC. SSC has to file the reply, objection filed, and assessing officer has to decide, and thereafter proceeding should be continued. So this proceeding has been incorporated in the provisions of section in this scheme by way of section 148A. And secondly, the search cases were that on the basis of incriminating material only, the assessment has to be made under section 153A as well as under section 153C. So both these provisions have generated to lot of litigation, and therefore this scheme with effect from 1/4/2021 came into existence to curb the litigation as well as for ease of doing business. So now we have to see as to whether these twin purposes, these objects have been satisfied under the new scheme or not. As we look through, it appears that this object has been frustrated. lot of litigation. I must say that 90% of the litigation in most of the high courts is in respect of reassessment only. The first of all, that after 1/4/2021, department issued lot of notices applying the TOLA Act. Actually, department in between 1/4/21 and 30th June 21 issued lot of notices under section 148 of the Act. And SSEs have initiated the litigation on the basis that these are barred by limitation. The first of the case is in the case of Allahabad High Court, that is Ashok Kumar Agarwal, in which case Allahabad High Court have held that an act of legislative substitution. I mean, Allahabad High Court have held that after 1/4/21, new act would apply, new reassessment scheme would apply. The substituted legislation, I mean, the TOLA Act will not supersede the substituted legislation. The legislative substitution is a composite act by which it involves simultaneous omission and reenactment. So by this very nature, once a new provision has been put into existence, then that would apply. And accordingly, in Ashok Kumar Agarwal, it was held that the notice issued by the assessing officer under 148 would not survive. Thereafter, number of cases flooded in the various high courts. Thousands and thousands of litigation was there. Even in Delhi High Court, Bombay High Court, all of the courts have held that the notices were time-barred. So ultimately, matter went. Allahabad High Court's decision in Ashish Agarwal went to the Supreme Court. Supreme Court had also agreed with the high courts that since 1/4/2021, new act would apply. But what had happened to that Article 142 was applied by the Honorable Supreme Court, which was never applied in respect to tax matters. And Honorable Supreme Court stated that everybody knows, I am in very brief, I am explaining this because everybody knows Ashish Agarwal. So Honorable Supreme Court stated that whatever notices have been issued by the assessing officer between 1/4/21 to 30th June 21 would be deemed as notices under section 148A(b) of the Act. Because Honorable Supreme Court was of the view that after 1/4/21, amended law would apply. And therefore, those notices, because 90,000 notices were issued by the assessing officers throughout the country, so those were treated as 148A(b) notices. Inquiry under section 148A(a) was dispensed with as a one-time measure. Thereafter, Supreme Court directed that assessing officer within 30 days would provide the material to the assessees along with material and information. Thirdly, the assessee would file the reply under section 148AC. Assessing officer would pass the order under section 148AD. And the most of the important was that all the defenses, those are available under section 149 of the Act, are available to the assessees as well as to the department. This is the direction which has generated the lot of litigation. It is not that along with Article 142, controversy was set at rest. That has given birth to lot of litigation, and I am coming to those litigations one by one. Before that, I say that as soon as the 148A notice is received by the assessee, what is to be seen? First of all, it is to be seen as to when the assessing officer signed the notice. Secondly, when this notice was served or received by the assessee, as to when it can be said that the notice was issued and dispatched by the assessing officer. Thirdly, it is to be seen as to whether approval is properly granted by the higher authority. whether the approval is granted by the appropriate authority, specified authority under section 151 of the Act. Next, the whether notice is served at the proper email ID of the SSC, whether the notice is served at the proper address of the SSC, because all this have generated the litigation. Then whether the DIN number is there on the notice or not. On the notice itself, it is not that it was given separately. Whether the notice is issued by the jurisdictional assessing officer or the faceless assessing officer, whether the material has been provided by the assessing officer along with the notice, whether how many days are granted to the SSC to file the reply, whether 7 days time is given or not, whether reply of the SSC has been considered by the assessing officer or not. All these things have generated the litigation on the aspect whether a personal hearing has requested by the SSC, then whether that personal hearing has been granted by the assessing officer or not. And thereafter, everything has been considered by the assessing officer or not. I am stating this only with respect to notices, that whether this has been considered by the assessing officer or not. Then whether foundational allegation is there or not, whether that material has live link with the income escaping assessment in the hands of SSC or not. So as soon as the notice is received by the SSC, everything has to be seen by the assessing officer and immediately has to file, because 148A notice is the jurisdictional notice that confers the power upon the assessing officer to initiate proceeding under section 148 of the Act. And therefore, this is the jurisdictional requirement. And therefore, if any lapse is there, then SSC has to file the writ petition, and those writ petitions are maintainable, and all the high courts have entertained. Next, it is to be seen whether it is on the notice is issued to the amalgamated company, whether notice is issued to the deceased person. I am coming one by one on each of the aspects. I am first coming, I have already discussed the Ashish Agarwal. I am not giving much of the time on Ashish Agarwal because everybody is knowing with respect to this. So I am coming to next, that when the notice is digitally signed by the assessing officer within the limitation period, but it is served on the SSC after the limitation period. Say notice is issued on 31st March 2021, but it is served, dispatched on 1/4/21 and received by the SSC on 2nd or 3rd or 6th. So whether that is valid. It is held by the various high courts. I am explaining one of the judgment on this, that notices signed digitally before limitation period, but emailed to the SSC after the limitation period. In these types of cases, notice under section 148 was held by the Allahabad High Court as invalid in Dauji Abhushan Bhandar. I will come to Rajiv Bansal later on. I mean, after discussing some of the judgment, I will come later on. That in Dauji Abhushan Bhandar, what have been stated by the Allahabad High Court, that section 282A1 explains the signing of notice and issuance or communication thereof have been recognized as different texts. I mean, signing of notice and issuance are the two different texts. Considering the provisions of section 282 and 282A and the provisions of section 13 of Information Technology Act 2000 and meaning of the word issue, firstly, the notice shall be signed by the assessing authority. Then it has to be issued either in the paper form or to be communicated in the electronic form by delivering or transmitting the copy thereof to the person therein named by the modes provided in section 282, which also includes dispatched under section 13 of the Information Technology Act. So as per section 13, unless otherwise agreed, the dispatch of the electronic record occurs when it enters into the computer resources outside the control of the dispatcher, outside the control of the originator, that is the assessing officer. That shall be the date and time of issuance of notice under section 148, read with section 149. So it is not only that notice has to be signed by the assessing officer within the limitation period, it has to be dispatched and real-time alert has to be sent to the assessee. That is the date and time of dispatch, and issuance completes only thereafter. So this is in Dauji Abhushan Bhandar. Thereafter, Madras High Court, if everybody interested in various cases, so that I may cite those cases. Otherwise, I will explain only one example.
Interested, ma'am? Interested?
Can I?
Yes.
So, Madras High Court in Srimati Parveen Amin Bhatra versus ITO 446 ITR 201, Madras High Court. In Sumanjit Agarwal, Delhi High Court cases that is 449 ITR 517. 5 categories were made by the Honorable High Court. That notice is signed on 31st and issued on 1/4. I mean signed, digitally signed and issued on 1/4. Different 5 categories are made. So in that case, relying upon Kanubhai M. Patel, Gujarat High Court judgment in 334 ITR 25, Honorable Delhi High Court held that expression issue in its common parlance and its legal interpretation means that the issuer of the notice must, after drawing up the notice and signing the notice, make an overt act to ensure due dispatch of the notice to the addressee. It is only upon due dispatch that the notice can be said to have been issued. So this is the clear-cut message by the Honorable High Courts. And various High Courts have followed. Other cases have that Rajasthan High Court, Tirupati Construction, 465 ITR 611, Allahabad High Court, Vikas Gupta, Delhi High Court, again Mohanlal Santwani, and again Allahabad High Court. Now the next category. Notices issued to a wrong email ID, because this small issue crops up before us. So what is to be done in those cases when the notice is issued to a wrong email ID? So in those cases, notice and reassessment has been quashed by the Kerala High Court in 4-Star Granite Private Limited versus DCIT. The SSC in this case contended that the department did not note the changes in the personal details of the SSC in the web portal, which was intimated by the SSC to the assessing officer. So Kerala High Court have quashed the notices that because despite the knowledge, despite the information, web portal address was not changed, and therefore reassessment proceeding was quashed. In this line, notice under section 148 served at wrong village address. That was held to be invalid by Gujarat High Court. That is Ishwarbhai Thakurbhai Patel versus ITO. SSC contended that he has not received any notice under 148. Still, reassessment proceeding was continued by the assessing officer. Notice was served on wrong address, so assessment proceeding and notices were quashed. Again in this line, notice served at the old address, though new address known to the AO. So it was held to be invalid. That is in Delhi High Court, Principal CIT versus Atlanta Capital Private Limited. So this is this line of, in this case, one more observation what Delhi High Court have held. that issuance and service of notice under section 147 and 148 are mandatory. That is the judicial requirement. The mere fact that SSC participated in the proceeding will not constitute a waiver of such jurisdictional requirement. Supreme Court has dismissed the SLP filed by the revenue against this judgment. So even if the SSC has participated in the proceeding, then also it cannot be treated as waiver of the judicial requirement. This is the most important observation by the Delhi High Court. Now the next line of cases, notice of reassessment is issued on the dead person. Everybody knows this Savita Kapila case and Gujarat High Court case and all that. Gujarat High Court in 444 ITR 405 observed that notice under section 148 is a jurisdictional notice which confers jurisdiction on the assessing officer to assess or reassess. Hence, notice issued against a dead person, 148 notice issued against the dead person, is without jurisdiction, is invalid unless LR submits to the jurisdiction of the assessing officer without raising any objection. Even reassessment upon the amalgamated company, that is also invalid. Lot of cases are there of that. The next line is that if minimum 7 days time stipulated in clause B of section 148A is not given to the SSC, the proceedings are vitiated. Madras High Court in G. Ravi Shankar versus ITO 445 ITR 296, notice dated 17th March 2022, under section 148A was issued giving time up to 21 din, only 4 days are given. Since minimum 7 days had not been given, this is the statutory requirement under section 148AB. So Madras High Court held that consequential proceedings are invalid. Other high courts, Delhi High Court has also in Divis Singh Kadan, that is 445 ITR 445. Even Calcutta High Court have made the observation that sufficient time has to be given to the SSC to file the reply. That is 466 ITR 494. Anup Kumar Agarwal versus Union of India. Now the case is order passed under section 148 AD ignoring the reply of the SSC. Whether that is valid. So Delhi High Court in Minu Chofla versus ITO. All these small points are very important, on the basis of which High Court has quashed the proceeding in favor of SSC. So we have not to wait as to what is to be done, or in appeal proceeding we will see. In writ petitions, High Courts are entertaining these writ petitions, ignoring the SSC's reply. In Minu Chofla, Delhi High Court have that SSC has the right to get adequate time to submit the reply. Though the SSC had filed an application for extension of time for filing its response, immediately after receipt of notice, the assessing officer neither rejected nor directed the SSC to file the reply. SSC made an application. It is the duty of the assessing officer to dispose it of. Either he has to reject it or direct the SSC to file the reply. That is Ajanta Chemical 215 idea. Everybody is very well aware of Supreme Court case. That assessing officer cannot sit on the application. He has to either reject it or allow it. So he has to file. He has to direct that SSC has to file the reply within the originally stipulated time. SSC filed the reply 3 days after the stipulated time. Assessing officer passed the order after having received the reply of the SSC. In these circumstances, Delhi High Court have quashed the proceeding initiated in pursuant thereto and 148A order as well as 148 notice. So even the reply assessing officer has to dispose it the application filed by the SSC. There are so many judgments by Jharkhand High Court, Meghalaya High Court, again Delhi High Court, in many cases Calcutta High Court. I will send Gupta ji my compilation to you so that it can be circulated amongst us, so that I cannot state. The one of the most important case on this aspect, that the reply of the SSC has not been considered by the assessing officer. That Delhi High Court judgment in Divya Capital One Private Limited versus ACIT. That is 445 ITR 336. In this judgment, I mean, High Court have observed so many points. In this case, Delhi High Court have held in this case that notice was very cryptic. The High Court held that notice and the order were cryptic, as was evident from the fact that information culled out from the SSC's own return and own records. So no outside information. What has been culled out by the assessing officer from the record of the SSC, that is not the information, and therefore that notice was not valid. Information is the mandatory requirement for, I mean, having the jurisdiction to issue the notice under 147. Secondly, in this case, information and material was not provided to the SSC. That is the mandate of Ashish Agarwal also. And even 148A(b) says that information and material has to be provided to the SSC to file the defense by the SSC. And thirdly, the reply was not considered. So all these aspects have been considered by the Delhi High Court. In the case of Divya Capital, it is an important case, I mean, that is 445 ITR 434 Delhi High Court. Again, in Divya, that information has not been shared. In respect to that, the observation is that under the amended provisions, the term information in explanation 1 to section 148 cannot be lightly resorted to so as to reopen an assessment. This information cannot be a ground to give unbridled powers to the revenue, whether it is information to suggest under the amended law or reason to believe under the erstwhile law. The benchmark of escapement of income chargeable to tax still remains the primary condition to be satisfied before invoking the powers under section 147. Merely because the department classifies the fact already on record as information that may vest it with power to issue notice under section 148A(b), but would not vest it with the power to issue the reassessment notice under section 148 of the Act. So similarly, like it is not the, I mean, suspicion gives power to initiate notice, does not give power to initiate proceeding under section 147. That is the old law, Lakhmani, Mevaldas and all that. Now, the next line of cases, in that line, when the foundational allegation is missing in the notice, it is to be quashed. That is Delhi High Court again in Kachi Prop Build Private Limited, that is 448 ITR 671. Show cause notice under section 148A(b) order under 148A(b) order under section 148A(d) and notice under 148.
मैडम आपकी आवाज कट रही है बीच बीच में.
अच्छा, जब कट जाए ना आप मेरे को बोलना. तो
प्लीज रिपीट करें.
मैं 1 मिनट लैपटॉप भी दो. राम ऊपर आना, वो लैपटॉप भी तू चालू कर दे. नहीं, ये आवाज कट रही है इसमें. इन कैची प्रोबेबिलिटी शो कॉज नोटिस. सर कट रही है क्या?
नहीं, हमको तो बराबर सुनाई दे रही है.
बराबर सुन तो
हाँ.
चल रही हूँ. जहां कटे वहां गुप्ता जी मेरे को वहां स्टॉप कर दीजिएगा. All the notice order were challenged on the ground that the notice under section 148AB was invalid as it did not contain any allegation of escapement of income. Gupta ji, you must remember Haryana acrylic, in which there was no allegation by the assessing officer that income escaping assessment. That allegation is not there. So similar observation is here by the Delhi High Court in catchy prop bill, that must have the allegation, that is the mandatory requirement, that income has escaped assessment in the hands of SSC. Now, that limitation part I am coming later on. Now I am on section 151. Small points I am explaining first. Na? Section 151, without application of mind. I mean, approval is not the mere idle formality. It is a check upon the arbitrary power in the hands of assessing officer. In Godrej Boyce, Bombay High Court Judgment 453 ITR 10, the principal commissioner had accorded the approval under 151, which showed non-application of mind. As well, all the documents, including his own earlier order, past dropping proceeding. I mean, initially, principal CIT had dropped the proceeding under section 263 of the Act. That 263 was not upheld. So, assessing officer initiated the proceeding under section 147 of the Act. So, Bombay High Court held that since the 263 file had not been considered while giving the approval by the CIT, and therefore this 148 cannot be upheld. In this line, and this judgment has been upheld by the SLP filed by the revenue against this judgment, this Godrej Boyce, that has been rejected by the Honorable Supreme Court. That while granting approval, there has to be application of mind. Even yesterday in Delhi High Court, I have argued one case on this non-application of mind. What has been happened in that case, that on 22nd August 2024, assessing officer issued the notice under section 148A(b) of the Act. And simultaneously, on that very date, the approval form was sent to the CIT. And in the column, that whether reply of the SSC was received, obviously on 22nd and 8th notice was issued to the SSC, so reply was not there. So he had stated in that column that no, reply of the SSC is not received. Everybody granted approval on that by the assessing officer, then joint commissioner forwarded, principal CIT forwarded, and principal CCIT has also granted the approval. So, so Delhi High Court quashed the notices 148A(d) order as well as 148 notice that application of mind has to be there. So Supreme Court has also rejected SLP of the revenue on this aspect. Number of cases that in Vodafone Bombay High Court, then in Goenka Line Chemical also, that is, even Supreme Court has rejected the SLP, that is reported at 453 ITR 242. And Delhi High Court, many of the judgments are there. Next, sanction under section 151 has to be by the specified officer. In Siddh Micro Equities, Bombay High Court, it is held that TOLA would not apply since 4 years had expired. Rajiv Bansal has explained this 151, whether TOLA would apply or not. So we should not waste our time on this aspect. But it is to be by the specified officer as per section 151 of the Act. Now I am coming to Rajiv Bansal. Rajiv Bansal, everybody knows with respect to that, but that is the most important. That is the most important case, and therefore I am shortly explaining that case. That aftermath, Ashish Agarwal's case, thousands of notices, showers of notices under 148 of the new regime were poured on the assessees by the assessing officer between July and September 22. Because on 4/5/22, Supreme Court judgment in Ashish Agarwal case, Supreme Court had directed to give the material to the assessees within 30 days. So, between July and September 22, for assessment years 13-14 to 17-18, after following the procedure mandated by the Supreme Court in the case of Ashish Agarwal. So against those notices, assessees came out with various grounds, various innovative grounds, challenging the legality and validity of those notices. Order passed under section 148 AD by the assessing officer. Because most of the notices, these were passed on September 22. After some of the, I'm coming to that when the orders were passed. So several High Court quashed these notices and the orders, holding that these notices were time-barred and that the same were issued without appropriate sanction of the specified authority. Most of the High Courts have held in favor of SSC, Allahabad High Court, Gujarat High Court, Bombay High Court, Rajasthan High Court, Odisha High Court, Delhi High Court. I need not name all these cases because everybody knows that all these High Court, Kinara Industries and Rajiv Bansal and have decided in favor of SSC. So revenue challenged these cases. Supreme Court spelled out two most important issues, that whether TOLA and the notifications issued under it will apply to the reassessment notices issued on or after 1/4/21, and whether reassessment notices issued under section 148 of the new regime between July and September 22 were valid. Because after 4/5/22, within 30 days material was provided, and thereafter, after receiving the reply of SSC between July 22 and September 22, this 148 AD orders and 148 notices were issued by the revenue. So Supreme Court made the following observations in this case. So Supreme Court said that on breaking down the ingredients of the proviso to section 149(1)(b) of the new regime, a notice under section 148 of the new regime for assessment year 21-22 and before, because it applies since 1/4/21. So proviso also said that 1/4/21 and before can be issued only if, as on the date of issuance of such notice, the time limit for issuance of such notice continued to exist under section 149(1)(b) of the old regime. Accordingly, if the period of 6 years from the end of the relevant assessment year has expired at the time of issuance of such notice, no notice could have been issued under the new regime. Revenue accepted that without application of TOLA, time limit for issuance of notice for assessment year 13-14 to 17-18 expired on or after 1/4/2021 as per new regime. Next observation, that Finance Act 21 substituted a new regime for reassessment. Accordingly, sections 147 to 151 of the old regime ceased to operate from 1/4/21. This is in favor of the SSC, that ceased. Next, after 1/4/21, any reference to the Act means the Act as amended by the Finance Act 21. Third, the time limit under the new section 149 for issuing notices operated respectively for 3 years for all situations and 6 years in case the escaped income amounts to or is likely to amount 50 lakhs or more. So Supreme Court has found out the via media, stating that TOLA would apply the unamended law, I mean existing before 1/4/21 and after 1/4/21 as well. If I may put to myself, I am putting the question that when this TOLA came into existence, amended law was not there. So how can TOLA would apply to the new law when the new law was not there at all? But Supreme Court has found out the via media, otherwise all the notices would have scrapped. So next, what Supreme Court held? That TOLA is a legislation enacted by the Parliament. Section 3(1) of the TOLA provides for the relaxation of any time limit prescribed under the specified acts for completion or compliance of any proceeding or passing of any order or issuance of any sanction. That is 3(1)(a) of the TOLA, which says that all the actions are issuance of any sanction, intimation, notification, sanction or approval which fell between 20th March 2020 and 31st March 2021. What Supreme Court thereafter says that Section 3(1) of TOLA is concerned only with the performance of actions contemplated. Sorry, friends. Section 3(1) of the TOLA is concerned only with the performance of actions contemplated under the provisions of the specified acts. Consequently, the amendment or substitution of a provision under the specified act will not affect the application of TOLA so long as the action contemplated falls between 20th March 20 and 31st March 21. So again, what Supreme Court says that TOLA would apply to the amended law as well if the compliance of action falls between 20th March 20 and 31st March 21. Hence, at the time of issuance of notice under Section 148, Revenue has to see two things. First, the time limit specified under Section 149 and the extent of relaxation provided by TOLA and its notification for issuance of notice. TOLA does not amend Section 149, but it has to be read along with Section 149. Say, for example, 6-year time limit for assessment year 13-14 as per old regime expired on 31st March 2020. But TOLA extended the time till 31st March 21. And TOLA extended till 30th June 2021. Revenue cannot extend the operation of old regime, but it can benefit from the extended time limit for completion of action falling between 20th March 20 and 21. And thereafter, Supreme Court has explained 151, said that simultaneously this approval also time has to be extended. So in respect, I am not explaining that 151, everybody knows that. So in respect of validity of 148 notices issued in June and September 2022, Supreme Court observed that in Ashish Agarwal, Supreme Court had created a legal fiction by deeming Section 148 notices as the notices issued under Section 148A(b) of the Act. Under Section 158A(b), the AAO has to comply with two requirements: issuance of show cause notice and supply of material. So what, for determining the limitation, what Supreme Court is saying, that since 20th March 20, till the reply is filed by the SSC, because by virtue of Supreme Court judgment till 4/5/22, that time has to be excluded for the limitation. Thereafter, time allowed to the SSC to file the reply, that is also to be excluded. And thereafter, I am in the wording of Supreme Court, I am reading the combined effect of legal fiction and the direction issued by the court in Ashish Agarwal is that the show cause notices that were deemed to have been issued during the period between 1/4/2021 and 30/6/2021 were stayed till the date of supply of relevant information and material by the AO to the SSC. After supply, the time begins to run for the SSC to respond the show cause notices. Thereafter, the third proviso to section 149 allows the exclusion of time allowed to the SSC. That is, third proviso says that the time taken by the SSC to file the reply, that is to be excluded from the limitation period. So thereafter, whatever time is remained, assessing officer has to consider reply of the SSC under section 148AC and next to take a decision under 149AD and issue the notice. So once the clock started ticking, the AO was required to complete his procedure within the surviving time limit. Even Supreme Court has given the example. Say that the notice is issued under section 148 originally under the erstwhile law on 1/5/2021, which was to be treated as show cause notice. If the SSC submits the reply on 18/6/2022, then the assessing officer will have 61 days from 18/6/2022, because from 1/5/21 to 30/6/2021, because 30/6/2021 Tola had extended the time to issue the notice. So therefore 61 days time is left. So after receiving the reply from the SSC on 18/6/2022, there is a time of 61 days for the assessing officer to pass the order under 148AD and notice under 148. Assessing officer has passed the order thereafter, and therefore the notices have to be held to be time barred. So everybody is clear with this Rajiv Bansal's case. So now in each case, SSC has to compute themselves the limitation as to when the assessing, after issuing the original notice, what time has been taken by the department to give the material, when the reply was filed, whatever the surviving period. Within that, I say that most of the notices would be found out time barred. In my cases, in many of the cases, notices are time barred. So this is the good ground. We have to compute in each and every case the limitation. So 50% of the cases will be wiped out by this judgment. Now, Hanji, sir. Now the new controversy also arises as to whether the notices were issued by the jurisdictional assessing officer or the faceless assessing officer. Various high courts have quashed the notices issued under section 148 by the jurisdictional assessing officer, stating that central government, in exercise of power conferred upon them by virtue of section 151(a), had introduced the e-assessment of income escaping assessment scheme 2022. Wide notification dated 29th March 22. This is reported at 442 ITR Statute 198. Clause 3B of the notification clearly states that the scheme would be applicable to the notices issued under section 148 of the Act. the object of introduction of faceless assessment would be defeated if show cause notices under section 148 are issued by the jurisdictional assessing officer. So the following high courts, say Punjab and Haryana High Court, Telangana High Court, Bombay High Court, Guwahati High Court, Calcutta High Court, Bombay High Court again, and many other high courts have held that the notices issued by the jurisdictional high court is not valid. But Delhi High Court and Gujarat High Court are against this judgment. They have decided in favor of revenue. Those two cases are TKS Builders Private Limited versus ITO. That is 2024. This is recent judgment. Within this month only. 2024 SCC Online Delhi 7508. And another Gujarat High Court judgment. That is Talati and Talati LLP versus ACIT 2024 Gujarat High Court 54567 DB. They have taken a view in favor of revenue. Thereafter, many of the judgment Bombay High Court time and again have held that the notice by JAO is not valid. One more, that even in the cases of international taxation, Bombay High Court in
Madam, voice is not coming.
Voice not coming. Ram, laptop la. ये मैं टैब से बोल रही हूँ. अभी आ
Madam,
रही
your voice is coming to me. That
Voice
means
is
there is
very
something
clear.
wrong at their end. No problem. Your voice is clearly coming. Please go ahead.
अच्छा सर, ये भी बहुत इंपॉर्टेंट है कि इवन इन इंटरनेशनल टैक्सेशन केसेस it is held that 148 notices are to be issued by the FAO, faceless assessing officer, and not बेटे वो खोल के मेरे को दे दे, and not by the JAO. That is in Abhil Anil Kumar Shah. What it has been held in this case, that even in cases assigned to the international taxation charge, which constitute one of the exception to the faceless assessment, because regarding faceless assessment, it is said that in these type of cases, physical assessment are to be there by the jurisdictional. So in these cases also 148 notices are to be issued by the JAO, by the FAO. Now the next case is opportunity of hearing. One case is also there, that non-furnishing of copy of approval under section 141. So Delhi High Court in TIA Enterprises Private Limited held that if copy of approval under section 151 has not been given along with the notice, that means that sanction has not been obtained by the assessing officer, and therefore reassessment is invalid. So while at the time of receiving the notice, it is to be seen as to whether DIN number is there on that. Abhi I am coming on that also, that whether TIN number is there, whether approval is given or not, whether information is not there. Many of the points initially I have stated that. Next is order under section 148, that I have stated that reply of the SSC has not been considered. But the SSC is not given the sufficient opportunity. Then also Calcutta High Court held that notice is invalid. Next line is notice issued on incorrect facts. Then also notice is invalid. In Krishna Diagnostic Private Limited, Delhi High Court, in 468 ITR 283, notice under 148 AB was issued on the ground that SSC had not declared capital gain. In the reply, SSC stated that I have not sold the immovable property. I have purchased the immovable property. His reply has not been considered. So in these circumstances, Delhi High Court has quashed the proceeding that it is issued on incorrect facts which are not existing at all, and therefore notice was quashed. Then Allahabad High Court, in one of the cases, Rahul Sachin versus ITO, stating that recording of regions not a prerequisite under post-2021 scheme of reassessment. This is very interesting judgment that is passed by Allahabad High Court, that legislature has departed from the strict test of recording of region to believe and substituted it with lighter and more subjective decision that it is a fit case for issuing notice under section 148 of the Act. That is, it is a fit case to reassess the SSE based on suggestion emerging from information that income in the hands of SSE which has escaped assessment. One Delhi High Court judgment in Manju Somani's case, that is also very interesting. In this case, Delhi High Court held that notice issued under section 148 in order to be sustained when tested on the anvil of old section 149(1)(b would have to meet the prescription of 6-year period of limitation, and that period in respect of 1617 ended on 31st March 23. In this case, assessing officer for assessment year 1617 issued the notice on 29/4/24. 6 years expired on 31st March 23. And therefore, so in all the years from 21-22 and before, it is to be seen as to when the notice is issued. If it is after 6 years, then those notices are time barred. This is because earlier we have not interpreted in this way. That is what 13, 14 and 14, 15 we were saying that those were time barred, and that 16, 17. 1 minute, sir. ये इसको एक बार ये नहीं आ रहा, इसको खोल कर अभी. Am I audible, sir? नहीं, मेरी आवाज नहीं जा रही.
आ रही आवाज आ रही है मैडम, आ रही है आवाज आपकी.
मैम आ रही है आवाज
आ रही है, ठीक है, ठीक है.
आवाज अच्छी आ रही है, पहले से अच्छी आवाज आ रही है.
अच्छा. In Manju Somani versus ITO 466 ITR 758, High Court held, ये मैंने कर लिया कि इसमें notice is issued in the year 24 when the limitation expired on 23. 6 years expired. In this case, there is no issue in respect to TOLA and all that. Simply, we have to see that as to whether notice is issued within 6 years from assessment for assessment year 21-22 and earlier assessment years. Then the next case is correctness of claim. Now the Hexaware Technologies Limited, that is the judgment passed by the Bombay High Court, is very important in many of the issues. Now that is before the Honorable Supreme Court. This Hexaware judgment, in this case, Bombay High Court have dealt with many of the issues. That I am discussing some of the issues in this case. That what Bombay High Court in this case. Under Chapter 6A, that is 80C to 80P and 80RR, all that, cannot constitute escapement of income under Section 149(1)(b) because it does not represent an asset. In Hexaware Technologies Limited, Section 80JJA provides for deduction of an amount equal to 30% of the additional employee cost incurred during the course of the business by the SSE in the previous year, and that is allowable in 3 assessment years, starting with the year in which the employment was provided. The correctness of the claim cannot be examined under section 147, as first, it is not an asset. Second, it is not the expense in respect of a transaction or in relation to an event. And thirdly, entry in the books of accounts. These 3 things, we have to see from this judgment, we have to take the lesson that we have to see the 3 things, because 149(1)(b) states so that whether it is an asset, whether that is the expenditure in respect of an event, and thirdly, whether it is the accommodation entry. It is not each and every expenditure that can be gone into by the assessing officer. That is not. Next, what have been considered in Hexaware, it is also held that when a notice under section 148 or any other action of the authority is contrary to law, that itself is prejudice, invalid and bad in law, liable to be quashed. SSC need not prove actual prejudice. So this is again very important. When any action of the revenue officer is contrary to law, that itself is vitiated in law and SSC has not to prove. Then the third principle in Hexaware, that limitation in the first proviso to section 149 would mean application of the old limit, that is 6 years and not 10 years. Again, because why this is so? Because first proviso says year, assessment year starting with 1/4/21 and before. So 10 years limitation period came into thereafter. So on which grounds the reasons given by the Bombay High Court in Hexaware that for assessment year 2015-16, TOLA and CBDT notification is not applicable. TOLA and that 11/5/22 notification of the CBDT is not applicable. Second observation is for assessment year 15-16, 6th year expired on 31st March 22. First proviso to C1 to section 149 provided up to assessment year 21-22, what I have said. Only from assessment year 22-23, period of 10 years would be applicable. Next, third observation, period of limitation and restriction under proviso to section 149 were provided in respect of notice under 148 and not 140. This is again very important. This was beyond our notice. That period of limitation is applicable to only notices under 148 and not 148A. The fourth observation, notice dated 8/4/21, originally issued under section 148, was treated as notice under section 148A(b) of the Act due to Ashish Agrawal. Hence, it was no longer relevant to determine that is what in Rajiv Bansal that Supreme Court have. The next important observation is Bombay High Court stating that even 5th and 6th proviso are not also applicable. 5th proviso to section 149 extend limitation by the time allowed to SSC to file the reply, stay granted by the court, that is to be excluded. So thereafter period cannot be excluded. In this case, the notice was issued in the month of August 22 and that was held to be time barred. In Hexaware, again, it was held that notice without DIN number is invalid. That is Brandix Mauritius. Honorable Delhi High Court have also said so, and that is before the Honorable Supreme Court. That case is pending before. Even Hexaware is pending before the Supreme Court. In this connection, what Honorable Bombay High Court held, that issuance of separate limitation letter or this is important because in most of the cases that DIN number is given by the assessing officers by separate letters. So Bombay High Court is stating that issuance of separate intimation letter or even date would not validate the notice issued under 148, since the intimation letter referred to DIN with respect to some notice under 148 dated 26/8/2022, 1 day before, and the notice was dated 27/6/2022, for which DIN was generated. The procedure prescribed in circular number 19 of 2019 had not been complied with. If DIN was not mentioned, then reasons, this notification is stating certain exemptions that in which circumstances DIN number is not to be taken on the same letter or notice or anything. That notice without DIN number is invalid. So in that para 3 of that circular, it is stating that if DIN cannot be taken, then the reasons are to be recorded by the assessing officer. So Bombay High Court is saying that if DIN was not mentioned, then reasons for the same are to be stated, recorded. No such reference is recorded in the notice, and the notice is invalid. In Hexaware, controversy regarding JAO and FAO was also there. One more controversy in Hexaware, in which it is held that AO has no power to review his own assessment when information was provided and considered by him during the original assessment proceeding. So concept of change of opinion is also applied here, that under the amended law also principle of change of opinion would apply. Assessing officer had allowed the claim under JJA after considering the reply of SSC documents and evidences and allowed the same. So for that purposes, 147 cannot be issued. In this aspect, Delhi High Court and again Bombay High Court is also there. One more important in this line, that Bombay High Court in MFE framework, I am stating the 464 ITR 645, stated that contents of revision order under section 263 cannot be the information. Once the 263 has been, or say that 263 is time barred. So for that reasons, 147 cannot be issued. It says that contents of revision order under section 263 cannot be information. Reassessment based on change of opinion. So this principle is also applicable under the amended law as well. One more judgment I am discussing of Bombay High Court in Karan Maheshwari versus ACIT. It states that if there is no live link between the material and belief about escapement of income, notice under section 148 and order under section 148 AD is invalid. So in this case, important observation is made by the Bombay High Court, stating that the reasons for the formation of belief that there has been escapement of income under 147 must have a rational connection with or relevant bearing on the information. Rational connection postulates that there must be a direct nexus or live link between material coming to the notice of AO and his view that there has been escapement of income in the particular year. It is not any and every material, howsoever vague and indefinite or distant, remote or far-fetched, which would suggest escapement of income. Power of AO to reopen an assessment, though wide, are not plenary. AO has to prima facie form the opinion regarding escapement of income. So this is again Lakhmani, Meval Das and Fulchand Bajrang Das and all those cases which has been incorporated in this judgment by the Bombay Court. So it is not each and every material. In some of the cases, what is happening, that survey is in some of the cases, somebody has statement is recorded of the third person, and on the basis that the accommodation entry by given is given by them, on the basis of that, notices are issued. No application of mind on the part of assessing officer. No inquiry by the assessing officer. This is only for these purposes that section 148A has been introduced. It is only in between 1/4/21 and 30th June 21 that as a one-time measure, inquiry under section 148A was dispensed with. But thereafter, assessing officer has to make inquiry. If there is no clear-cut information, there is no nexus, no live link, then assessing officer has to make inquiry. And that is now in the amended provision with 1/9/2024. That is incorporated in section 148A. Now I am coming to that scheme which is applicable from 1/9/24. I have not given much time on that, but in short, I am 148A. This says that now, because even vide and drive shaft has also been incorporated, many of the High Court judgment that 7 days time is not given, reply is not considered, and all that. So this is the changed scheme. That before what it says, that before making the assessment, reassessment, or recomputation, that shall be subject to section 148A. 148 says. So 148 says that where the 147 and 148, there is no much difference, but difference is in section 148 capital A. Which says that where the assessing officer has information which suggests that income chargeable to tax has escaped assessment, in the case of an assessee for the relevant assessment year, he shall, before issuing any notice under section 148, provide an opportunity of being heard to such assessee by serving upon him a notice to show cause as to why a notice under section 148 should not be issued in his case, and such notice to show cause shall be accompanied by the information which suggests that income chargeable to tax has escaped assessment, in his case for the relevant assessment year. So, at the time of issuing notice only under section 148A1, opportunity of hearing is to be given to the assessee. This hearing means, in my understanding, it is personal hearing. That even reply sufficient time is to be given to the assessee, and even personal hearing has to be given. Then 2 says that so here A and B has been merged. That in each and every case, opportunity is to be given. So in my understanding that 148A, small a and B have been merged into 148A1. B says that on receipt of notice under subsection 1, the assessee may furnish his reply within such period as may be specified in the notice. Then third, assessing officer shall on the basis of material. So this is 148A, C and D are the same. So A and B have been merged. And thereafter, no much difference. The 151, there is a difference. That now the approving authority is additional director, additional commissioner, joint director, and joint commissioner. So principal CCIT and principal CIT or CCIT and CIT are omitted. So now by the lower authority that is to be given. And it is stated that any notices issued before 1/9/21, any 148A or 148 notices issued before 1/9/21 are to be handled, are to be governed by the erstwhile provisions existing before 1921. Now the search cases are being dissected from here. Again, chapter 14D is there. That 148A, B, C, and BD scheme, again, block period and all that. That is there. That is but from here, from 148 jurisdiction, that has been directed such cases. Survey cases are there in this. So this is with reference to. Now, Gupta ji, any question that can be?
Madam,
Anything
before
is left,
we come to
then
the
that
yeah,
maybe
no,
I
no,
can
no,
explain if
yeah,
anything is left.
yes, madam. Before we come to the question answers, and I'll request the Prohit also to make a comments. I have few issues on which
Hanji.
I would like you to further elaborate and give specific answers to that. Kindly, you may note down. I have 5-6 points. In fact, you can explain thereafter.
Ek minute.
Yes. You have explained the subject very well, and you have, in fact, prepared your thesis, in fact, on this. This all case laws, so many things, all controversies you have explained very well. But there are a few issues which I'm just pointing
Sir.
out. Firstly, with reference to the decision of Rajiv Bansal, there is a lot of confusion whether assessment year 2015-16 will be the status about the notices issued for assessment year 15-16. So I'll request you to kindly throw light on that. What will be whether they will be valid or not. Secondly, with reference to the decision in the case of Manju Somani, that was for assessment year 2016-17.
Yes.
And in that case, the facts were that notice under section 148A(d) was also issued after 31st March 2023, after the end of the 6 years. And thereafter, the D notice and the D order and the 148 were issued sometime thereafter. This is why the courts had taken, the Delhi High Court has taken a view that this notice was after the 6 years period. Now, I am giving an example, or let us take a case. Ki notice under section 148A clause B was issued, say, for assessment year 16-17 before 31st March 2023. Say, for example, on 28th March 2023. And then time was provided to the SSC of 7 days as per the notice. Then reply was given by the SSC. And then thereafter, say in June 2023, the order notice under section 148 was issued after passing the order under 148A. So now the section 148A, as you rightly mentioned in your discussion, provides for exclusion of the time from issuing the notice to the time provided to the SSC. Then what will be the status in respect of those cases? Because there are many cases, as you very well know, before the Delhi High Court. Whereas for assessment year 16, 17, 17, 18, the position has been the notice under section 148A, B has been issued before March, but 148D and notice on 148 have been issued after the March of the after expiry of 6 years. So what will be the status of that? Thirdly, that if the earlier notice was issued under section 1, second notice on the basis of the same information, that is the point which is, with that point is also pending before the Delhi High Court. So this first notice was issued, assessee filed the reply thereto. Then assessing officer was required to pass the order under section 148A clause D within 30 days. No order was passed. Now, after the lapse of 2 years, say for example, another notice has been given based on the same information. So what is your view about that? Then with the fourth point is that after the notice under section 148A(d) has been passed, assessment has to be done.
Sir, एक-एक करके पूछेंगे तो it would be better. नहीं तो
आपने नोट किया तो मैं सारा इकट्ठा पे एक्सप्लेन करके
करके तो ठीक है, बहन ठीक बोल रही है.
ठीक है, okay. So the 3 issues I have raised, kindly explain them. Then I have 3 further points. This is for the benefit of all of us.
Very correct. Very correct.
Correct. Please.
In respect to 2015-16, revenue
Yes.
itself have accepted that for 15-16 TOLA would not apply. Why so?
Yes.
That for 2015-16 3-year period, because after 1/4/21 even Supreme Court is saying that amended law would apply and TOLA would
Correct.
apply to amended law as well. So anything,
That's right.
any notice or any limitation which falls in between 20-3-2020 to 31st March 2021, for that TOLA
Yes.
would apply. Okay? Otherwise
Correct.
not.
Correct.
So for 2015-16, again Supreme Court said that we under the amended law we have to see 3 years period, because if it is below 50 lakh, that only within 3 years notice can be issued and not thereafter. And as per first proviso, 6-year periods. So Supreme Court have deliberated only on these two aspects. So for 15-16, 3-year period would expire on 31st March 2019. So that is before 20th March 20. So that for 15-16, 3-year period has been expired much earlier and therefore TOLA would not apply. So any notice issued in between 1/4/21 to 30/6/21, that is only valid, which has been fall between 20-3-2020 to 31-3-2021. For that purposes, 3 months are allowed. That is from 1/4/21 to 30/6/21. Am I correct, Gupta ji?
Very right.
Am I
Very right.
correct?
The 3 years, it is not a question of 3 years. Let us come to 6 years cases
6
only.
years. Now we come to 6
Yes.
years. For 2015-16, 6 years
Yes.
expires on 31-3-2022. So 31-3-2022, again this would not apply. 15-16 के लिए, because notices are issued after वो जुलाई से सितंबर के बीच में notices issue किए. Supreme Court is with respect to July to September 22 notices. So any notice issued because the limitation expired on 31-3-2022. Now you consider Manju Somani. Now you consider that.
नहीं, sorry.
नहीं,
As
तो
far as this
इसीलिए
particular point
मैंने
is concerned,
एग्जांपल दिया कि वो 31-3-22 को खत्म हुआ. 148 नोटिसेस आर इश्यूड बिटवीन. अब सोमानी पे मैं आ रही हूँ क्योंकि अर्लियर मुझे क्या लगा कि मंजू सोमानी इज कॉन्ट्रेरी टू गुलाटी एंड टचस्टोन, क्योंकि उसमें ये कहा हुआ है कि 50 लाख से ऊपर की जो है उसके लिए दैट इज वैलिड, दैट नोटिस. बट फिर मैंने मंजू सोमानी पर तो मेरे को लगा कि दिस इज कॉन्ट्रेरी टू गुलाटी syndicate and touchstone both, but that is not so, because I read Manju Somani twice and I thought that that interpretation can also be given to this provision. तो ये क्लियर हो गया राजीव बंसल का?
नहीं मैडम, my point is that Rajiv Bansal
करते.
yes, you see, say for assessment year 2015-16, initial notice was issued in June 2021. Right?
June 20.
After June 2021, within the extoller time. Then after that, Ashish Agarwal says that this notice is to be
148A, 148AB.
Notice. Right. Now this Rajiv Bansal says that in view of the judgment of Ashish Agarwal, time taken from issuance of the notice till the reply is given by the assessing, after whole procedure after the Ashish Agarwal, is to be deemed as period stayed by the court, and with that is to be excluded. So if we exclude that period, then notice issued in July, after July 2022 till September, which is the period, for assessment year 15-16, will be within the period of 6 years. If that period is excluded.
Gupta ji, kindly see, it is directly hit by first proviso to section 149(1)(b), and therefore there is no need to consider the limitation as per
नहीं,
proviso 5th and 6th. I mean, at the threshold, it is hit by first proviso. क्योंकि first proviso
madam,
says,
under
हाँ
the
जी,
old law also, if the period is stayed by the court, then that period was to be extended. So now Rajiv
जो
Bansal
हम
says
उस
that
पे
that
भी आ रहे
period
हैं,
will be deemed to be.
sir, even we are
जी,
on your point as well. You are saying that on June 21,
yes,
original notice is issued. That may be
correct,
said
correct.
that on 15th of June, that is. Then 4th, in view of
That
Ashish
was
Agarwal in the
that was
month
with
of,
that was
in
that
the
was
month
within the
of,
period.
within a period of 30 days, 4/5/22 से within a period
That
of
was
30 days.
that
That
June
I mean the
2021
reply
notice
till
was
the
within the period
reply.
of 6 years.
Sir, I am on that only.
Please,
कि
please.
हाँ, आप ये कह रहे हैं ना कि notice is issued on 15th of June 21. At that point of time, 6 years were
Right,
not
right,
expired. ठीक है ना? उसके
right,
बाद
right, right.
148A(b) till reply is given
Hmm.
by the SSC, that period is
Correct.
excluded. Now, then
Excluded.
when July 22 came, at that point of time, 6 years were already expired.
Madam,
Madam,
so yes. Sir, Prohit
अब
sir,
जब
would you like to add on this
प्रोवाइजो
point?
से हिट हो गया फर्स्ट
नहीं
प्रोवाइजो से,
नहीं
क्योंकि आप ये
मैडम,
देखो
here
एक पैरा में बताऊं, उसमें इन्होंने कहा है कि इवन 5th and 6th प्रोवाइजो वुड नॉट से.
Madam, here we are not on proviso. Here, let us consider the stay. Rajiv Bansal's case. We have considered stayed. Sir, Prohit sir, would you like to add on this point, sir?
I am not very clear on this issue, but what it seems that what Mrs. Bansal is saying, that if that 6 years time has expired on 30th June 2022. Am I right, madam?
31st March 2022.
Yes.
31st March को expire हो गया.
31st March 2022. And then Ashish Agarwal has come later.
No,
so
sir.
That
Ashish Agarwal.
4/5/22 को आया.
Ashish Agarwal judgment is later. So then that time extension that has been given by the Supreme Court is correctly calculated by Mrs. Bansal, that on 31st March 2022, 6 years had already elapsed. So once that time limit, that and the proviso itself provides in section 149 that in those cases where the notices could not have been issued, say on 31st March 2021, after 1st April 2021, then no notice can be issued. So that principle will still apply according to me, because on 31st March 2022, 6 years have elapsed. So you cannot give notice thereafter.
प्रोफेसर, वो गुप्ता जी कह रहे हैं कि 148 की इनिशियल नोटिस 15 जून 2021 को दी गई थी.
ठीक है.
बिफोर दी आशीष अग्रवाल केम इन. आशीष अग्रवाल आया, उन्होंने बोल दिया कि ये जो भी नोटिस है 1/4/21 से 30/6/21 के बीच में हुई है, हम इसको आर्टिकल 142 लगाकर आपको इसको डीम्ड नोटिस मानते हैं. अब डीम्ड नोटिस मान के उन्होंने बोल दिया 1 महीने के अंदर में आप इसको इंफॉर्मेशन और मटेरियल दे दो एसएससी को, और एसएससी को बोला कि 15 दिन के अंदर में आप जवाब दे दो. अब आया राजीव बंसल. राजीव बंसल बोला कि साहब इन कंटिन्यूएशन टू आशीष अग्रवाल 112 पैराग्राफ में उन्होंने एग्जाम्पल देके आपको समझाया है कि ये पीरियड एक्सक्लूड हो जाएगी. पीरियड 15 जून 21 से लेकर 30/6/21 के बीच के ये सर्वाइविंग पीरियड है, और 1/7/21 से लेकर टिल द रिप्लाई इज अ डीम्ड स्टे पीरियड. तो डीम्ड स्टे पीरियड में आपका रिप्लाई के बाद में वो 15 दिन जो बोल रहे हैं गुप्ता साहब, वो ऐड हो जाएंगी. तो आपका प्रोविजो 1 जो है वो काम नहीं करेगा. वो सुप्रीम कोर्ट जब बोल ही रहा है, जब हमारा पिताजी जब बोल रहे हैं तो कोई ऑप्शन नहीं है साहब हमारे पास में. क्वेश्चन हमें यह लग रहा है साहब, इस क्वेश्चन को हम लोगों को पैराग्राफ नंबर 108 पढ़ना चाहिए राजीव बंसल। मैं
करेक्ट करेक्ट।
यदि आपका परमिशन है मैं पढ़ूं, तो 4-5 लाइन
हाँ,
है।
पढ़िए पढ़िए, क्योंकि हमारे पास अवेलेबल नहीं है वो अभी।
हाँ, मैं पढ़ देता हूँ। देखिए, पूरा राजीव बंसल का केस ये तोला को लेकर है, आइदर 3 इयर्स टाइम लिमिट को लेकर है या 6 ईयर टाइम लिमिट को लेकर है। हाँ, ठीक है। एम आई ऑडिबल?
या
सर
प्लीज प्लीज गो अहेड।
सर मैं आप 108 पैरा पढ़ने से पहले एक बात कह दूं, तो हमें वो पैरा अंडरस्टैंड करने में थोड़ा बेनिफिट होगा। मैं ये कहना चाहती हूँ कि टोला वुड अप्लाई ओनली टू द एक्शंस विच फॉल्स बिटवीन 20-3-20 और 31-3-2021।
Agreed. I agree. That is why I am telling you to kindly read 108. I am
हाँ,
also with you, madam.
इसीलिए मैंने ये
ये
बात बीच में कह दी
ये
कि हमें
नहीं
अंडरस्टैंड
मैडम,
करने में।
इसलिए काइंडली
हाँ,
मैं बोल रहा हूँ, यहाँ लिख रहा है, देखिए मैं बीच की लाइन 2-3 लाइन पढ़ रहा हूँ सिर्फ।
नहीं पूरा
Therefore,
पैरा पढ़ लीजिए।
पूरा पैराग्राफ पढ़ लूँ?
हाँ
मैं
जी,
पूरा
हाँ
नहीं,
जी।
3-4 लाइन पढ़ता हूँ। Therefore, the logical effect to the creation of the legal fiction by Ashish Agarwal Supra is that time surviving at the Income Tax Act read with TOLA will be available, जो आप बोल रहे थे, surviving period read with TOLA will be available to the revenue to complete the remaining proceeding in furtherance of the deemed notice, including the issuance of the reassessment notice under section 148 of the new regime. The surviving balance time can be calculated by giving the number of days between the date of issuance of the deemed notice and the 30 जून 21। तो इसमें मेरा अपना मानना है मैडम कि मैं आप लोगों का सबका व्यू, गुप्ता जी का भी व्यू और आपका मैडम व्यू जानना चाह रहा हूँ। चूंकि 15-16 में 6 ईयर की पीरियड में टाइम पीरियड 31 मार्च 2022 को खत्म हो रही है, बोला नहीं है 31 मार्च 21 को। तो सुप्रीम कोर्ट ने जो बोला है कैटेगरी 1 के लिए 13, 14, 14, 15, कैटेगरी 2 16, 17, 17, 18 के लिए, कैटेगरी 2 3 ईयर का लेकर है, कैटेगरी 1 6 ईयर्स को लेकर है। तो कैटेगरी 1 और कैटेगरी 3 को लेकर वो बोले जहां तोला लगेगा, तोला अवेलेबल है, वहां पर आप वो सर्वाइविंग पीरियड को ऐड कर दीजिए फ्रॉम द डेट ऑफ द रिप्लाई। लेकिन 15-16 में तो मैडम तोला नहीं है। तो
वही
मेरा
मैं कह रही हूँ, वो
हाँ,
मैं भी वही
नहीं,
कह रही हूँ कि
लेट मी
टोला इज
कंप्लीट
नॉट एप्लीकेबल।
मैडम, लेट मी कंप्लीट।
हाँ जी।
जो 1 कुछ फायदा नहीं करेगा इसमें मैडम, अपने हार जाएंगे। ठीक है, हमें ये कहना है, हम तो ये आर्गुमेंट पोजीशन लेनी चाहिए कि सर्वाइविंग पीरियड यहाँ ऐड नहीं होगा बिकॉज 31 मार्च 21 को तोला नहीं है 15-16 के लिए। ठीक है, तो मैं सर्वाइविंग पीरियड जो 15-16 का लिए 15 जून 2021 को जो इशू हुआ है, तो 15 जून 2021 से लेकर 30-21 के पीरियड के बीच में 16 दिन का जो सर्वाइविंग पीरियड है फ्रॉम द डेट ऑफ द रिप्लाई वो ऐड नहीं होगा। लेकिन एक साथ 21 से लेकर अप टू डेट ऑफ रिप्लाई वो एक्सक्लूजन जरूर होगा। बीचों बिकॉज आशीष अग्रवाल बोल दिया, फिर राजीव बंसल भी बोल दिया। तो मेरा अपना मानना है मैडम, 15-16 के लिए आपने सर्वाइविंग पीरियड ऐड मत करिए। इसका मतलब हुआ जिस दिन हम रिप्लाई किए उसी दिन उसको 140 की नोटिस देनी है। नो, प्रोविजो 4 इज देयर। प्रोविजो 4 बोलता है कि आपको 7 दिन का मिनिमम टाइम होनी चाहिए आईटीओ के पास में टू पास दी ऑर्डर। आज पर फाइनेंस 2021 में प्रोविजो 4 था, बाद में प्रोविजो 6 हो गया। तो उसमें 7 दिन फ्रॉम द डेट ऑफ द रिप्लाई जोड़ दीजिए। वो 7 दिन के बाद में यदि 140 नोटिस देता है तो अकॉर्डिंग टू मी वो असेसमेंट आउट ऑफ टाइम लिमिटेशंस है, नहीं है, और विद इन द 7 दिन के अंदर में तो विद इज वैलिड नोटिस। ये मेरा गुप्ता जी अपना मानना है। नाउ आप अपना
नहीं, प्रमोद जी बिल्कुल सही पॉइंट समझे हैं जो मैं कहना चाह रहा था। अब इसमें मैं थोड़ा सा और फर्दर ऐड कर दूं कि राजीव बंसल में ये कहा कि दैट इनिशियल नोटिस विल बी डीम्ड टू बी नोटिस अंडर सेक्शन 148A। लेट अस नाइदर इट टोला इज एप्लीकेबल nor let us go to the proviso exclusion for the proviso।
पर सर इसमें डीमिंग प्रोविजन का सवाल कहाँ आता है?
नहीं, मैं डीमिंग प्रोविजन की बात नहीं मैडम,
इश्यू ही नहीं आ रहा इसमें 15-16 के लिए।
डीमिंग प्रोविजन की बात नहीं कर रहा हूँ। What my view is that Rajiv Bansal says that period from that notice वो नोटिस तो डीमिंग होगा। जो नोटिस जून 2021 में किया, वो नोटिस तो आशीष अग्रवाल ने कह दिया ऑल द नोटिस विल बी डीम्ड टू बी अंडर सेक्शन 148A। उसमें तो कोई डाउट नहीं। आज वंस दे हैव सेड,
मैं
देन
वही
राजीव बंसल
आपसे
से
डिफर कर रही हूँ गुप्ता जी, मैं वहीं पर डिफर कर रही हूँ,
प्लीज प्लीज प्लीज
क्योंकि नया लॉ है तो
जी
15-16 के लिए 3 साल के लिए तो नोटिस इश्यू ही नहीं कर सकते, और 6 साल के लिए इश्यू कर सकते, तो 6 साल का पीरियड अभी भी लेफ्ट है। 31/3/21 को आप कह रहे हो कि 15 जून 21 को इश्यू किया, तो 6 साल का पीरियड तो स्टिल
करेक्ट।
सर्वाइव। तो डीमिंग प्रोविजन का सवाल कहाँ आया? आशीष अग्रवाल अप्लाई ही नहीं करेगा उस नोटिस को, एम आई राइट? उसको क्यों अप्लाई करेगा?
I think let us leave this issue here itself. जो there appears to be
ये जो मैडम बात कह रही हैं बिल्कुल सही कह रही हैं कि जब 30 जून 21 को तोला अप्लाई इसलिए नहीं होगा क्योंकि वो 31/3/22 को लिमिटेशन है उसमें।
हाँ, तो इसलिए आशीष
और
अग्रवाल अप्लाई ही नहीं
एक
करेगा।
जजमेंट कल आ भी गया है इसके ऊपर दिल्ली हाई कोर्ट का।
मंजू सोमानी,
नहीं, एक और आ गया अभी।
हाँ अभी एक और आया है, अभी
हाँ मैं बता
रिसेंट
देता हूँ
आया।
आपको, मेरे पास है, उसका नाम है गुप्ता एंड कंपनी प्राइवेट लिमिटेड वर्सेस चीफ कमिश्नर ऑफ इनकम टैक्स 14 नवंबर 2024।
हाँ बिल्कुल अभी आया है।
और उसमें दिल्ली हाई कोर्ट ने राजीव बंसल की लाइन बड़ी इंपॉर्टेंट है, वो कोट करी है, मैं पढ़ के सुनाता हूँ आपको। विदाउट द प्रोवाइजो टू सेक्शन 149(1)(b of the new regime, the revenue could have had the power to reopen assessments for the year 2012-13 if the escape assessment amount exceeds 50 lakhs. Meaning by because of this proviso, the notice cannot be issued. 149(1)(b का जो proviso है, that is very important.
Sir, with due respect,
बिल्कुल ठीक है, बिल्कुल ठीक है,
with due respect,
बिल्कुल
गुप्ता
ठीक
जी,
है,
with due
बिल्कुल ठीक है।
respect,
अच्छा
मंजू सोमानी का फैक्ट्स जो है डिफरेंट है सर।
और लोगों के क्वेश्चन ले लीजिए, देयर आर अदर पीपल आल्सो।
प्रमोद जी, let us leave this issue here itself.
I am stopping myself.
यस मैडम, नेक्स्ट इशू जो मैंने मंजू सुमानी के केस में जो आप कहा कि नोटिस का पहले आ गया 148A का बी का, पर जो वो 148D और 148 बाद में आया, तो उस पोस्ट में क्या पोजीशन रहेगा?
सर मंजू सोमानी, हाँ जी सर, जो मंजू सोमानी में होल्ड करा है वही हेक्सावेयर में भी होल्ड किया। अच्छा, मैं वो प्रोवाइजो फिर से पढ़ रही हूँ, दैट इज उसका वर्ड टू वर्ड पढ़ना और समझना, दैट इज वेरी इंपॉर्टेंट। इट सेज दैट प्रोवाइडेड दैट नो नोटिस अंडर सेक्शन 148 shall be issued at any time in a case for the relevant assessment year beginning on or before 1st April 2021. I mean for assessment year 21-22 and earlier assessment years, not thereafter.
ठीक है।
If a notice under section 148 or 153AC could not have been issued at that time. अब ये 148 की बात कर रहा है, 148A की बात नहीं कर रहा है, ये 148 की बात कर रहा है, ठीक है?
बिल्कुल ठीक है,
On account of being beyond the time limit specified under the provisions of clause B of subsection 1. अब समझिए कि आप 16-17 का ही हम साल ले लें, 16-17 का साल, आप इसमें वो सब भूल जाइए, टोला वगैरह, क्योंकि टोला इस प्रोवाइजो में कहीं एप्लीकेशन नहीं है।
टोला कोई मतलब नहीं इसमें,
टोला का कोई मतलब नहीं। 16-17 के लिए 31/3/2023 को खत्म हो रहा है। अब अगेन मैं पढ़ रही हूँ, इफ अ नोटिस अंडर सेक्शन 148 could not have been issued at that time, समझो कि ये नोटिस जून 23 में इश्यू किया है, तो अंडर द अनएमेंडेड लॉ, अंडर द ओल्ड लॉ, आई मस्ट से कि 30/6/2023 को नोटिस नहीं इश्यू कर सकते, क्योंकि 6 साल खत्म हो गए, 31/3/2023 को खत्म हो गए। If a notice under section 148 could not have been issued at that time on account of being beyond the time limit specified under the provisions of clause B of subsection 1 of this section. मतलब
ठीक है, मतलब
149
आपका व्यू
1B
यही
में
लग रहा है।
इसमें
हाँ, नहीं,
टोला बोला
ठीक,
कि कहीं बात नहीं है। आप
नहीं,
ये
टोला की
समझो
बात
कि
नहीं,
149
नहीं,
1B में 6 साल का टाइम खत्म हो गया, तो इवन अंडर द
बिल्कुल
अमेंडेड लॉ यू कैन नॉट इश्यू द नोटिस।
बिल्कुल ठीक है, मतलब आपका भी यही है कि 148A का जो एक्सक्लूजन है टू प्रोवाइड द टाइम, दैट हैज नो मीनिंग एज फार दिस
No meaning.
पर्पस इज कंसीडर्ड। ओके,
Yes.
fully
Yes.
agreed with that. अच्छा, the third point I was mentioning
हाँ,
that earlier notice was given, the
ये
assessing officer
फिर
has
से
not
बताएं,
passed the
फिर से एक
earlier notice was given under 148A clause B based on
हाँ,
certain information with the assessing officer.
हाँ,
Assessee had given a reply.
हाँ,
Now D order was not passed. D order was not passed, which he was supposed to pass within 30 days. Now after 2 years, he again gave the notice based on the same information. So what is your view about it? Can it be done or can it not be done?
Sir, it cannot be done because
Right.
the first proceeding is continued. आपको याद हो KLM रॉयल डच एयरलाइन, गुप्ता जी आपको याद है KLM रॉयल डच एयरलाइन CS अग्रवाल ने आर्ग्यू किया था, उसमें उन्होंने कहा कि when one proceeding is not culminated into the end, another proceeding cannot be initiated. आपने 148AB का ओपन है प्रोसीडिंग, उसको आपने ऑर्डर पास नहीं किया, तो आप दोबारा, इट वुड अमाउंट टू चेंज ऑफ ओपिनियन, और वो नहीं कर सकते। जो दैट इज माय ओपिनियन, दैट कैन नॉट बी डन।
नहीं, योर ओपिनियन अपीयर्स टू बी परफेक्टली राइट। क्वेश्चन यही आता है कि उसने डी का ऑर्डर ही पास नहीं किया था, ही वाज सपोज्ड टू पास, तो वी कांट से कि प्रोसीडिंग्स आर गोइंग ऑन, प्रोसीडिंग्स हैव ऑलरेडी finished. In fact, he was supposed to pass the order within 30 days,
but
which he
he
has not
cannot
passed.
again issue the notice.
So
कोई
my
नई
view is also that,
information है, if some new information has come, then he can do.
of course, that is a separate issue. So my view is also that once he has not passed the order within 30 days, it means he has accepted my reply.
Yes.
And then on the basis of same information, it cannot be raised. Now, मैडम, बहुत सारे केसेस में असेसमेंट्स जैसे हुए बेस्ड ऑन द सेम ऑर्डर, उसने जो डी का ऑर्डर पास किया उसी को फॉलो करके उसने असेसमेंट भी कर दिया। Assessee had not gone in earlier stage and the rate based on the order or notice at that stage. Now after the assessment, what do you suggest? The assessee should go in the writ or they should go in the normal appeal where there is a violation of principles of natural justice, or order was not valid, or notice was not valid,
सर
all
उसको
those things, or
अपील
reply
में,
was not considered.
सर उसको अपील में जाना पड़ेगा, अपील में जाना पड़ेगा। आप जुरिस्डिक्शनल एस्पेक्ट इसमें क्या लोगे आप कि 148D ऑर्डर वाज नॉट वैलिड, इसमें ग्राउंड क्या बनेगा रेट का? आई डोंट थिंक एनी ग्राउंड वुड बी अवेलेबल।
डी का मेरी
जुरिस्डिक्शनल
रिप्लाई थी,
एस्पेक्ट,
डी का ऑर्डर भी कंसीडर नहीं किया गया, असेसमेंट में भी ऑर्डर मेरी रिप्लाई कंसीडर नहीं की प्रॉपर्ली, बेस्ड ऑन द रॉन्ग फैक्ट्स असेसमेंट ऑर्डर हैज बीन पास्ड।
Gupta ji, appellate authority is empowered to consider all this.
Right, ठीक है, agreed, that's what
So
I'm saying.
the alternative remedy thing will come into play, you know.
yes,
you're right, sir. Now coming to the amendments, in the amendments, all this time period provided in the law earlier, 7 days, 30 days, and filing a return 3 months, all this period has been eliminated from the relevant sections, though the 3 months overall period has been provided. So now what will be the implication of this, and how the controversies will arise in this, and what will be the issues? Because now it is in the hands of the assessing officer how much time he is given, and there is no scope for extension also. There is no provision, as earlier was that in the assessee could apply for the extension of time for giving reply or filing return. Now there is no provision for that.
But the principle of natural justice will still apply, because natural justice principle is applicable even if there is no provision in the act. The natural justice has to be followed.
सर पर नेचुरल जस्टिस से लिमिटेशन तो उसको ऑब्जर्व करनी पड़ेगी। जो 5 साल का टाइम है, 5 साल 3 महीने से ऊपर हो गया तो ही कैन नॉट इश्यू नोटिस अंडर 148।
टाइम लिमिट विल अप्लाई।
वो अलग चीज है।
Principles of natural justice can be considered up to the limitation only.
Yes,
Sir, 5 साल
that's correct.
हम ये क्यों सोचे कि assessing officer will issue the notice only at the last day of the limitation period. He can also issue earlier as well.
Yes.
और उसके बाद 3 महीने का टाइम तो है एसएससी को भी।
प्रिंसिपल ऑफ नेचुरल जस्टिस विल बी एप्लीकेबल।
गुप्ता जी और कोई क्वेश्चन हो तो ले लीजिए, छोटा छोटा।
मैडम एक लास्ट इशू जो है, लास्ट इशू जो अभी नए लॉ में 30 सितंबर तक का टाइम दिया गया डिपार्टमेंट को टू इशू द नोटिस। उन्होंने बहुत सारे नोटिस इशू करे। अब उन नोटिस में जो पहले प्रॉब्लम थी वो उस तरह की प्रॉब्लम भी रही। उसके लिए हाई कोर्ट गए हैं या जा रहे हैं या मैटर पेंडिंग है?
30 सितंबर फॉर 143(2) कह रहे हैं आप, किसके लिए 30
नहीं
सितंबर?
ये जो नोटिस 148 ए जो इसमें
ये तो 1/9 के
हाँ,
बाद नया लॉ आया।
1/9 के बाद, सॉरी 31 अगस्त से,
हाँ,
31 अगस्त से पहले
सर मैं आपको कॉल करता हूँ, वेबिनार में हूँ अभी।
नोटिस दिए उन्होंने। वो नोटिस में वही प्रॉब्लम जो पहले प्रॉब्लम थी, वो उस तरह की प्रॉब्लम अगर होती है कि उसने जो हमारी रिप्लाई कंसीडर नहीं की, प्रॉपर टाइम नहीं दिया, या वर्क डिफेक्ट निकला या जो भी है, और हम हाई कोर्ट अब गए उसके लिए, और हाई कोर्ट ने सेटिस्फाइड करके और वापस भेज दिया कि सेटिस्फाइड कर दिया उसने कि दिस नोटिस और द ऑर्डर अंडर 148 इज सेटिस्फाइड। नाउ वो पीरियड 5 ईयर हो गया है। नाउ व्हाट विल बी द पोजीशन इन दैट रिगार्ड?
सर
क्योंकि
हाँ सर, मैं बताऊं, मैं समझ गई आपकी क्वेरी। सर इसमें क्या है कि जो भी नोटिस 148A या 148 के अंडर 30/8 तक इश्यू हो चुके, उसमें पुराना लॉ अप्लाई करेगा, 1/9/21 के बाद का नहीं अप्लाई करेगा। तो हमारे को कोर्ट ने रिमांड बैक कर दिया, पर उन्होंने 148A(B) का नोटिस क्वेश नहीं किया है। 148A(D) और 148 का नोटिस क्वेश किया है। ऑर्डर 148A(B) का नोटिस यदि वो क्वेश हो जाता है तो फिर आपकी बात सही है, 5 साल का पीरियड वुड बी अवेलेबल।
नहीं मैडम, 31 अगस्त से पहले इसको 148 के नोटिस इशू करने थे। 31 अगस्त से पहले 148 के नोटिस।
सर वो ये कह रहा है 140 यहाँ पर
नहीं
148A
का नहीं।
हाँ सर, मुझे
A-B का नहीं, उसने 148A-D का ऑर्डर और 148 का नोटिस इशू कर दिए। वो करने थे 31 अगस्त से पहले, जो ओल्ड लॉ विल अप्लाई, वो उसने कर दिए। अब वो नोटिस अगर सेटिस्फाइड हो जाते हैं, और अब जो है 5 साल का पीरियड हो गया, टाइम 6 साल का पीरियड था, तो अब उनका क्या स्टेटस रहेगा?
सर देखो,
गुप्ता जी
नॉर्मली सेक्शन 152 का सब क्लॉज 4 पढ़ रही हूँ, विच इज रेलेवेंट।
जी
152(4) जो नया है, वेयर इन ए केस अदर देन दैट कवर्ड अंडर सबसेक्शन 3, वो 132A वगैरह का है। A notice under section 148 has been issued, or an order under clause B of 148A has been passed prior to 1st day of September 24. The assessment, etc., in such case shall be governed as per provision 147 to 151 existing before the commencement of। तो इसका मतलब जहां 148A का ऑर्डर पास हो गया और 148 का नोटिस इश्यू हो गया 31/8 तक, तो अब कोर्ट ने तो वही क्वेश किया है ना, 148A(D) का ऑर्डर और 148 का नोटिस। तो सर यहाँ आपकी बात मुझे सही लग रही है कि जब वो 148A(D) का भी क्वेश हो गया और 148 का नोटिस भी क्वेश हो गया, तो नाउ ऑर्डर इज पास देयर आफ्टर, तो आपकी बात सही लग रही है कि वहां फिर 5 साल का पीरियड आ जाएगा। पहले मुझे ये अंडरस्टैंडिंग थी कि 148A(B) का नोटिस क्वेश नहीं हुआ, पर यहाँ है कि 148A हैज बीन पास, D ऑर्डर, तो वहां ये लग रहा है कि नया लॉ अप्लाई। हाँ,
एक्चुअली
सेट
सेट
मैं
असाइड
वही
और क्वेस्ट, हाँ,
तो
अगर वो सेट असाइड
क्योंकि
कर रहे हैं तो क्या
क्योंकि
स्टेटस
हाँ
रहेगा?
सेट मैं आपकी क्वेरी अच्छी तरह से समझ गई हूँ कि उसमें 148(a)(d का ऑर्डर सेट असाइड कर दिया और 148 का नोटिस, तो इसका
भी
मतलब
सेट
कि
असाइड कर दिया।
31/8 तक
हाँ,
148(a)(d भी एग्जिस्ट नहीं करता और 148 का नोटिस भी एग्जिस्ट नहीं करता।
आज एग्जिस्ट नहीं करता, अब नया दोबारा उसको करना पड़ेगा 148 का,
अब
विच हैज
दोबारा
बिकम टाइम
करेगा
बार्ड।
तो दोबारा करेगा तो दैट इज आफ्टर 19, तो वहां 5 साल
राइट,
की लिमिटेशन आ गई, तो वो नहीं कर सकता।
करेक्ट
वो आप
करेक्ट।
बिल्कुल सही कह रहे हैं।
गुप्ता जी और कोई क्वेश्चन ले
नहीं
लीजिए,
नहीं, राइट
आपके
राइट,
बहुत
थैंक
हो
यू
गए।
थैंक यू थैंक यू। नहीं नहीं, थैंक यू वेरी मच। नहीं नहीं, मैडम ने बहुत अच्छा
सर पर
एक्सप्लेन किया
ये
सब कुछ जो है।
सबके
और कोई
बेनिफिट
लोगों
के
के
लिए
क्वेश्चन है
है
क्या,
ये
अदर
क्वेश्चन।
क्वेश्चंस और दूसरे लोगों
अब
के?
हाँ, रोहित सर, सर कुछ आप ऐड करना चाहेंगे?
अभी आप क्वेश्चंस ले लीजिए, ऐड करने की तो
ठीक है
फिर बाद में कर लेंगे हम।
ठीक है ठीक है।
अदर पीपल आर वेटिंग, लेट अस टेक देयर क्वेश्चंस।
क्वेश्चंस किसके? लेट अस स्टार्ट, एनीबॉडी हु वांट्स टू आस्क एनीथिंग?
हेलो, मैं केतन
हाँ जी,
सतनालिया बोल रहा हूँ। केतन सतनालिया
जी जी
बोल रहा हूँ कलकत्ते से।
हाँ जी, बताएं बताएं।
हाँ, मेरा क्वेश्चन ये है कि जो आप सेट असाइड की बात कर रहे हैं, अभी
जी
क्या हो रहा है कि आईटीओ ने 2 दिन की नोटिस दी थी रिप्लाई देने की, आपने 2 दिन में जवाब नहीं दिया तो उन्होंने एक्स पार्टी ऑर्डर करके छोड़ दिया, और उसको जब आप अपील में गए हैं तो आज के दिन वो सीआईटी अपील उसको सेट असाइड कर दे रहे हैं। तो इसका मतलब ये हुआ कि आपने वो सेट असाइड करके ऑर्डर को, आईटीओ को एक अनदर लीज ऑफ लाइफ दे दी, तो ये कहां तक जस्टिफाइड है और इसका क्या कोर्स ऑफ एक्शन होना चाहिए?
सर जो आपने कहा कि आपको 2 दिन का टाइम दिया, तो
हाँ
that itself is a ground to file the writ petition, because many of the High Court have said that
हाँ
less than 7 days time cannot be given.
नहीं, वो तो ठीक है, उस समय तो
That is the statutory. और
रीट में नहीं
आप
गए।
अपील में गए हैं तो अपील में भी वो क्वैश होना चाहिए।
उन्होंने क्वेश्चन नहीं कर रहे हैं, वो सेट असाइड कर दिया ना, उनके पास अभी पावर आ गया सेट असाइड करने का, तो वो
हाँ,
सेट
सेट
असाइड
असाइड
कर दे रहे
करने
हैं।
का पावर आ गया।
वो सेट असाइड कर दे रहे हैं, तो सेट असाइड करने के बाद तो अब उनको आईटीओ को फ्रेश लीज ऑफ लाइफ मिल गई, वो दोबारा से अच्छी तरीके से जितने भी हमने पॉइंट लिए थे वो सारे करेक्शन करके फिर वो असेसमेंट दोबारा करेंगे।
नहीं सर, असेसमेंट क्यों करेंगे? पहले
वो
तो वो 148(a)(d करना पड़ेगा उनको।
हाँ, जो भी है वो सारे
वो
सारे
148(a)(d करना पड़ेगा, तो जो आपको सेक्शन 152(4) अप्लाई करता है क्या, वो टाइम बार्ड हो जाएगा। जो 5 साल से ज्यादा है
हाँ, तो
तो वो टाइम बार्ड हो जाएगा।
नहीं तो
नहीं
अपील
नहीं
अपील के ऑर्डर
मैडम,
के।
इफ आई अंडरस्टूड करेक्टली, इस केस में असेसमेंट ऑर्डर हो गया, उसके अगेंस्ट ये अपील में गए।
हाँ,
अपील में जो इन्होंने जो भी इशू लिया कि भाई 2 दिन का टाइम दिया, रिप्लाई कंसीडर नहीं करी या ऑब्जेक्शन जो भी किए, उसने असेसमेंट ऑर्डर को सेटिसाइड करके असेसमेंट ऑर्डर करने के लिए दोबारा भेज दिया।
नहीं
तो
पर
उसमें
सर
तो मतलब
वहां
दिक्कत
हमें
आएगी।
इंसिस्ट करना चाहिए कि हमारा 148(a)(d क्वैश हो। वहां पर हमें डी क्वैश करवाना चाहिए, नहीं कि असेसमेंट ऑर्डर,
वो नहीं,
क्योंकि
वो तो
प्रोसीजरल लैप्स तो वहां पर है।
वही तो दिक्कत अभी 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 जो मैंने पहले जो
अब तो जो है वो
मैडम जो
असेसमेंट
अभी
हो
मैंने
गया।
पहले इशू रेज किया था यही था कि उस स्टेज पे जब अपील में चले गए ना, तो प्रोसेस खत्म हो गया सारा। Process
वही
has come to an
बिल्कुल,
end once the
वी
assessment is
हैव टू
done,
बी।
and I am in appeal
अब
against the assessment order.
बात बात
तो
ये है कि वो जो हो गया सो हो
वो
गया,
दिक्कत आएगी इसमें,
रेमेडी
कोई
क्या है?
ठीक नहीं नहीं, ये
जो
सर वो
प्रॉब्लम
तो
रहेगी
फिर
इसमें जो है।
गुप्ता
वो
हाँ,
तो
जी
सर
समझ रहे
वही
हैं,
है,
गुप्ता
एनी
जी
अदर
असेसमेंट
समझ
क्वेश्चन?
ऑर्डर।
रहे हैं। अजय बोरा जी
हाँ
लास्ट लास्ट सेमिनार में बोले थे कि सब
जी,
ये क्वैश होना चाहिए, लेकिन मोस्ट ऑफ द कोर्ट्स आर सेटिंग असाइड दिस इश्यूज। तो बोला ये कोर्ट का
वो तो हाई
डिस्क्रिशनरी
कोर्ट की बात थी।
कोर्ट के डिस्क्रिशनरी की चीज है, उसमें करने का कुछ नहीं है। अपने सेटिस्फाई नहीं तो और हायर फॉर्म में जाइए, आपको
नहीं
हो
नहीं,
पाएगा।
यहाँ
लेकिन
तो सीआईटी अपील की बात हो रही है
चलो,
यार।
यहाँ तो
हाँ
कमिश्नर अपील ने किया है ना, ये
हाँ,
प्रॉब्लम है
कमिश्नर
ना।
अपील नहीं किया है ना।
एनी अदर क्वेश्चन?
सर वो सर मैं यहाँ पर यही बात सुझाना चाहती हूँ कि अपील में हम कह सकते कि 148(a)(d का ऑर्डर क्वैश सेट असाइड करे।
नहीं, वो सब तो सब सारा ले लिया हमने, आर्गुमेंट्स ले लिए, लेकिन वो तो अपने तरीके से चलते हैं ना।
हाँ वो तो
उन्होंने
ठीक
अपना सेट
कह रहे हैं,
असाइड कर दिया,
वो
वो
ठीक
कहेंगे
कह
नहीं,
रहे हैं कि
वो
हाँ,
अपना अपनी
और
स्कीम
कोई
के हिसाब
क्वेश्चन
से
है क्या,
चलेंगे
एनी
ना।
अदर क्वेश्चन गुप्ता जी?
नारायण जी एक
सर
क्वेश्चन करूं मैं?
नहीं
हाँ
नहीं,
प्लीज
आपका हो
प्लीज।
गया। Let
हमारा
us
हो
give
गया?
chance to others. प्रमोद जी,
अच्छा, ठीक।
दूसरों को साथ दे।
ओके,
Yeah,
ओके,
let
थैंक
people
यू,
present.
थैंक यू। सर मुझे एक क्वेश्चन है।
आज बताएं, योर नेम?
सर माय नेम इज अनीश शाह फ्रॉम बॉम्बे।
Okay.
So this is not directly on 148, but the tendency of the department of the last 10-15 days, I just wanted to share for the benefit of all. ये जजमेंट आने के बाद जो अगस्त में उनका टाइम वार्निंग मैटर खत्म हो गया, तो इशू डिपार्टमेंट 148 इशू नहीं कर पा रही है। अभी वो लोग ने इन्वेस्टिगेशन विंग और ये सब से इंफॉर्मेशन मंगाने का चालू कर दिया। 5 years के इंफॉर्मेशन मंगा रहे हैं from financial year 18-19 onwards till 23-24। तो इंटरनली ये लोग क्या कर रहे हैं, अपना राइट्स रिजर्व करने के लिए फॉर शेयरिंग ऑफ इंफॉर्मेशन, कि तुम्हारे जो भी डिटेल्स असेसमेंट कंप्लीट हो गए हैं, दे वांट टू यूज दैट रूट कि भाई गैदरिंग ऑफ इंफॉर्मेशन एंड रीओपनिंग। तो इज दिस एक्शन जस्टिफाइड ऑन द पार्ट ऑफ डिपार्टमेंट? सी दीज आर नॉर्मल नोटिस इशूड, तुम्हारा परचेस का डिटेल, सेल डिटेल, बैंक डिटेल्स, ऑल दोस डिटेल्स दे आर आस्किंग। कोई स्पेसिफिक इंफॉर्मेशन नहीं है उनके पास।
सर वो तो फिर सेक्शन 135A भी तो है ना, कि वो इंफॉर्मेशन मंगवा सकते हैं। सेक्शन 135A में लिखा है कि उनको अप्रूवल भी लेने की जरूरत नहीं है, तो वी कैन नॉट स्टॉप द
तो
डिपार्टमेंट।
मतलब सी ये लोग क्या,
नहीं वो
तो वी कैन
एक्चुअली
नॉट स्टॉप द
क्वेश्चन
डिपार्टमेंट, वी हैव टू गिव द इंफॉर्मेशन। मतलब स्क्रूटनी का टाइम खत्म हो गया है, तो अभी उन लोग को अपना राइट्स रिजर्व करने हैं।
नहीं एक मिनट अनिश जी,
तो बैकडोर एंट्री हो गई ना ये 148 के लिए।
अनिश प्लीज, मैडम ने ठीक कहा कि दे हैव ए वाइड पावर टू गेट द इंफॉर्मेशन मंगा लेंगे, बट रीओपनिंग के लिए तो अभी 5 साल का टाइम पीरियड है। इफ इट हैज ऑलरेडी एक्सपायर्ड देन दे हैव नो पावर टू रीओपन द केस। इंफॉर्मेशन मंगाने से ना मंगाने से कुछ नहीं होगा, वो तो असेसमेंट का टाइम, बस इंफॉर्मेशन भी उसी में मंगाएंगे जो 5 साल का पीरियड है जहां पर, अदरवाइज दे विल हैव नो रेमेडी अवेलेबल टू देम। सो आई थिंक इट इज
5 साल का है उसकी ही बात कर रहा हूँ मैं। 1920
तो उसमें मंगा सकते हैं, उसमें इंफॉर्मेशन मंगा सकते हैं, एंड दैट इंफॉर्मेशन कैन बी द बेसिस फॉर रीओपनिंग। एनी अदर नेक्स्ट क्वेश्चन प्लीज।
I think Gupta ji, we should conclude. And please, our former ITIT member, CA Sushil Pransuka ji is with us. He is honorable member of the Federation, because Kakra ji has left for some work. So can we request Sushil Pransuka ji, Sushil Pransuka ji to please propose vote of thanks. Sushil भाई, और सुशील जी हमारा हर प्रोग्राम अटेंड करते हैं।
नहीं वे तो मैडम ने आज बहुत अच्छा किया है, सब कुछ ग्रेट रियली
एनीथिंग बेनिफिशियल फॉर द मेंबर्स।
नहीं बहुत बढ़िया आपने जो है।
सर लेट मी एक्सरसाइज माय राइट ऑफ कमेंट व्हिच आई हैड डेफर्ड।
यस
प्लीज सर।
गुप्ता जी आपकी जाती है, उनका राइट अटेंड कर रहे हैं आप।
We are extremely thankful to Mrs. Prem Lata Bansal. She had done very extensive research on this subject and has given a very elaborate discourse on the subject, which is beneficial for all of us. And I just want to point out that in respect of jurisdiction issue of JO and the faceless assessment, the matter is pending before Supreme Court in the case of Surya Lakshmi case. So matters are now being blocked by the High Court for want of that judgment. And most likely, Surya Lakshmi will come in favor of the department. That is what looking to the trend of the Supreme Court. I feel that Surya Lakshmi will come in favor of the department. So we should be ready to argue over cases on other issues other than jurisdiction and time limitation. Time limitation issue has already been decided by the Supreme Court very recently.
Very right.
That is also against the SSC. So we should be ready to argue over cases on other points. So rather than going into these time limitation and other things, we should focus on the issues which we have raised in our cases. And I am thankful to Mr. Gupta ji that he has allowed me a time to comment upon. Thank you very much, sir.
This is my pleasure.
Sushil Pransuka ji, please.
Yeah.
Sushil ji, please.
Thank you, Jain ji and Gupta ji. And Prohit ji has made my task very easy by preempting the vote of thanks. In fact, Madam has very elaborately articulated the nonsense of this 148 provisions, which have become very, very complex nowadays because of various complications due to Ashish Agrawal case, the Rajiv Bansal case, which have ignited the very, very useful discussions. And I thank Mr. Gupta ji also, who has raised many, many questions, very, very vital questions, and especially assessment year 15-16, which is a point of controversy among all the professionals. I will digress for a minute here, and regarding the 15-16 assessment year controversy will go on, but I am on the side of the BP Gupta ji that 15-16 assessment year above 50 lakhs are valid notices. I have reason to say, and the reason is also have been submitted by the VP Gupta ji. I salute his interpretation, because you see, we have to read the judgment as a whole, not the paragraph wise. And concept of this exclusion period has been mandated by the Supreme Court in the Rajiv Bansal case, that from the date of deemed notice to the date when notice was going to be time barred, that period has to be excluded. So the argument that 31st March 22 time has gone has no legs, because on that day assessing officer was prohibited by to take the action. That was the whole concept of the Ashish Agrawal judgment, that assessing officer was prohibited to take action. So that time was allowed to the assessing officer. So if that period is excluded, so naturally on 31st March 22 he could not have issued no notice. That is the precise point Ashish Agrawal and the Rajiv Bansal says. So on that point, if notices are issued in July to September 22, then notices are valid. Be that may, it will still, there will controversy. I don't want to create further controversy, but Madam has made very, very, very intelligent and very, very, she has done very thorough job and handle the questions. I once again thank her. Thank you. Okay.
Thank you, sir.
Thank you.
Thanks a lot, madam. Thank you very
Thanks
much.
to our learned speaker, Prem Lata Bansal ji, our chairman of the committee, VP Gupta ji, Ganesh Purohit ji, Sushil bhai, and all of you for kindly participating in this program.
Now, I may inform all the next Saturday also, we have another Zoom meeting, which will be addressed by Mr. Salil Kapoor, advocate from Delhi, and he is an ex-ITT member. And the topic is that important issues and guidance regarding the handling of assessment and appeal proceedings in faceless regime, in the light of the income tax provisions and the CBDT instructions. So that is again
my friend. He's my batchmate in the
right.
ITT.
So that is again a practical issues, practical aspects, how we should look at the assessments and the appeal proceedings, how we should handle them, how we should reply the notices, etc. So there is all the practical aspects will be discussed in this Zoom meeting. So I'll request everyone to join next Saturday, same time, 5 o'clock. Right. Thank you very much. Thanks a lot, madam. Thanks a lot. Thanks to everyone for joining today.
Thank you.
Thanks you. Thanks to Sushil ji. Thanks a lot, sir. Right. Okay.
Income below.